Hello, welcome to Attorney Mayu's channel. Here, I talk about legal issues that foreigners in Japan may encounter. Today, I'm gonna talk about handling non-payment issues in Japan. When you are operating business, sometimes you will encounter people or company who doesn't pay. I also encounter at least one per year, disappointingly. To avoid non-payment, the best way is to have your fees paid before offering your service. Though oftentimes you cannot use such prepayment due to business customs, power balance with your customers, and such. So, if you have to offer your service before getting paid, always state clearly payment deadlines as well as payment conditions in writing, whether in letter or emails. When payment is delayed, promptly communicate with the debtor. Email, call, letter, whatever way is fine. But emails and letters are good for evidence, and I think call is the best way to put pressure on the debtor. You may hear some excuses from the debtor, but do not trust them fully. If you are serious about getting paid, then take actions. If you have some debt payable to the debtor, then you can offset your debt to the debtor with the debtor's debt owed to you. When you do this, send a certified letter so that you can prove later that you made a statement of intent to offset them. You can also make another agreement if the debtor agrees to it. In such an agreement, you should include a provision in which the debtor acknowledges her debt to you. And be sure to make clear the payment deadlines and include a provision on delay charges. You can set the rate of delay charges up to usually 14.6% in a contract. If you do not set such rate in your agreement, the rate will be 3% under Japanese Civil Code. In addition to such a debt acknowledgement agreement, it's better to have a guarantor also sign the agreement. A guarantor is a person who promises to pay the debtor's debt when the debtor defaults on her obligation. It is even better if you can have the agreement with a certain provision and get it notarized. The certain provision is about debtor's consent to forcible execution. It goes like this. The debtor hereby acknowledges that she will be immediately subject to forcible execution when she does not perform her monetary obligations provided herein. If you have this provision and have the deed notarized, then you can start proceedings of forcible execution without an official court decision. It means that you can skip lawsuit proceedings. These agreements are all based on the debtor's consent to enter into such agreements. If the debtor does not agree to such an agreement and does not pay despite of your demand, go to court, get a court decision, and proceed with the forcible execution proceedings. For lawsuits, you can consider three options: ordinary proceedings, small claims lawsuits, and proceedings for payment demand. You can choose ordinary proceedings regardless of the amount of your claims, though generally, these proceedings are the most time-consuming of the three. If your claim is 600,000 yen or less, and your case is simple and the debtor defendant has no objection to the proceedings, then you can file a small claims lawsuit with the summary court. Under these proceedings, you will generally have just one hearing. So if your case is complicated and it is expected that your case extends to more than one hearing, your case may be sent to an ordinary proceedings. Third option. If you have sufficient documents to prove the debtor's non-payment, you can file proceedings for payment demand with the summary court, regardless of the amount of your claims. When there is no objection from the debtor within 2 weeks after the receipt or service of such payment demand, and when the court decides your evidence is sufficient enough to prove non-payment, then the court will issue a payment demand with a declaration of provisional execution. It should be noted that you have to proceed with a forcible execution within 30 days after such decision. If the debtor lodges an objection to such a decision, then the case will be sent to an ordinary proceedings. In all three, you have to proceed with a forcible execution, otherwise court decisions you get will become a pie in the sky. Today's tips are: to avoid non-payment, always state clearly payment deadlines as well as payment conditions in writing. When payment is delayed, promptly communicate with the debtor. If the debtor does not pay regardless of your demand, you have three options: to offset, make another agreement, or go to court. It is recommended to consult with a professional when you make another agreement or go to court. Thank you for watching. For more information about me and my office, visit this website. I also accept online legal counseling so that you can seek legal advice even if you are outside Tokyo or abroad. Have a great day.